Your tenant just broke his lease, packed up and left. You're holding a security deposit. The security deposit is forfeited because the tenant broke the lease, right? That's what we would think. It's actually illegal. My name is Harry Heist, and I'm the founding partner of Heist, Weisse Wolk, the property manager's partner. Under Florida law, there are only certain things that you can charge a tenant when a tenant breaks the lease. One of the things that you think you could charge the tenant, but you can't, is the security deposit. Many property managers think that when a tenant breaks the lease, the security deposit is forfeited. It only makes sense. The tenant broke the lease. Why should they be able to keep their security deposit? Well, it's not legal. Up until about 2003, almost every property manager would forfeit the tenant's security deposit automatically if the tenant broke the lease. It was the normal thing that was done. It was the logical thing. I think you should be able to. But what happened is a court case came down in 2003. In 2003, many apartment communities and many property managers were charging things like early termination charges. They were charging lease break fees, notice fees, all kinds of fees. So when a tenant broke their lease, they would be charged quite a bit and, of course, lose their security deposit. Well, an individual decided to file a class action lawsuit against a very large real estate investment trust. And what happened when they did this is that the court decided that only certain things could be charged when a tenant broke their lease. And forfeiture of a security deposit was not one of them. You see, what happened in this case, this is a circuit court case. What happened in this case was that the judge looked at Florida law, and the judge said that Florida law does not state specifically that a tenant forfeits their security deposit if they break the lease. The law talks about if a tenant breaks the lease that they owe rent until the unit is re-rented. They owe rent according to the terms of the lease. But the law doesn't state anywhere that a security deposit is forfeited. So the judge's interpretation of the law was that if the law does not specifically say something's allowed, then it must not be allowed. Now, this is a way of interpreting the law. This is a type of judicial thinking. I personally don't agree with it, but my feelings and what I think really don't matter. So what happened was in 2004, when the case was decided, everything had to change. Everyone had to stop automatically forfeiting a security deposit when a tenant broke a lease. Now, the reality is a lot of people still do it. I see it all the time. I see notices of intention to impose claim on security deposit, and I see right there, lease break fee. The property manager forfeited the deposit because the tenant broke the lease. If that were to be challenged in court, that property manager could really have a problem. Now, what can a property manager charge when a tenant breaks a lease? Well, they could charge rent as it becomes due under the terms of the lease until the unit is re-rented. They could also charge the rent that's owed at the time that the tenant breaks the lease. If the tenant hasn't paid July's rent and breaks the lease on July 15th, they certainly owe all the rent for July, but they don't automatically forfeit that deposit. Wait a minute, does that mean they get their deposit back? That would be absurd, wouldn't it? The tenant broke their lease, left in the middle of July, maybe paid July's rent. Would they get their deposit back? No. Most likely they wouldn't. And the reason why they wouldn't is because you have 30 days to do your claim on the security deposit. You have 30 days to make the notice of intention to impose a claim on the deposit. So by August 1st or August 5th or August 10th, when you're still within your 30-day time frame, the tenant owes another month's rent. And that month's rent will be taken from the security deposit. So the tenant would not get back that security deposit, as you could see, but it would not be automatically forfeited. Make sure your lease doesn't have any type of automatic forfeiture clause in it. Another item that some leases have in it is called an acceleration clause, and we see that in commercial leases where it's allowed. You can't accelerate the rent due under the terms of the lease when a tenant breaks the lease. You would think that you might be able to, but you can't. When a tenant breaks the lease, they owe the rent that's due at the moment they break the lease, and the rent as it becomes due until the unit is re-rented or the lease is up, whatever occurs first. Action item would be to examine your lease and then look at your process, because a lot of people, even though the lease doesn't have an auto forfeiture clause in it, which would not be legal anyway, a lot of property managers will just automatically forfeit the security deposit upon lease break. So we need to stop that, and we need to really understand what the tenant owes and act accordingly. If you have any questions about this topic or any other topics, please feel free to email us at info@evict.com.